I'm already in chapter 5 here. I'm going to move to chapter 6. This has to do with the core of the book and the main idea behind chapter 6. I'm not claiming this is the solution. What I'm doing is to put ideal scenario, as I'm going to explain here. I'm going to follow Rolfe, A Theory of Justice in particular, not his book, and I'm going to make clear that later, his methodology. I'm going to do what he did at the level of the individual, and I'm going to put the parties of any sovereignty conflict, representatives from Argentina, the United Kingdom, and the Falklands, Malvinas, or representatives of Russia, Crimea, and Ukraine, or representatives of the United Kingdom, Spain, and Gibraltar. I'm going to put these representatives with a set of rules, and I'm going to ask them to decide who the sovereign is over Crimea, over Falklands, or over Gibraltar, Kashmir, Jerusalem. This is the whole skeleton of chapter 6. First of all, I'm going to set the rules for the negotiation, so how these people are going to behave and what kind of rules are going to apply. The main point would be who may be part of these negotiations. Do we consider people in Crimea? Do we consider people in the Falkland Islands? Because for one of the parties, usually, it is the case that we're not going to even consider what these people think, or because they've been implanted, or because they are not part of our population, or because we don't share the same ethnicity. Yeah. For whatever reason, usually one of the three, or one of the four, in the case of Kashmir, we have 4 parties, does not recognize any other. So I'm going to deal with the who may be part. In law, that has to do with admissibility. Yeah. If we think as a lawyer in criminal law or in civil law, that's the first step. Who may have a claim, who may have a case to answer. That's called admissibility in law. That's what I'm incorporating here to Rolfe methodology. Then I'm going to go into the negotiations, and then I'm going to discard or disagree with certain potential solutions. They are not working right now, and they'll never work. If we only focus on the historical approach, who was there first, or who is more related to that community, we'll never find a solution, and I'll explain why. I follow as well an author here. I use his theory to discard the historical account. And then I'm going to offer one of many solutions. It's not the solution, again, I'm claiming here. For me, I'm more interested in what we call in legal philosophy, jurisprudence, procedural justice. I'm interested in the procedure, yes? And to offer fairness in the procedure. If tomorrow Russia decided to use this procedure, and tomorrow they came up with independence, or annexation, or whatever the solution, as long as we follow procedural justice, it is up to the parties to decide. So I'm going to only offer what I think would be the ideal solution. Yes? In reality, I'm not interested in the outcome. In reality, I'm interested in offering the parties a floor for discussion in which they are all equal. Yes? And I'll define what I mean by equal, because it sounds very ideal, but I'm going to define what I mean. Very briefly here, I'm not going to spend time. I'm simply recognizing in international relations we have what we call pluralism. Same roles at society level. We are all different. We have very large countries, Russia and Argentina, very small countries in terms of territory, the UK, and very large countries and small in terms of population. We have rich countries and poor countries in many senses. We tend to think about finances or natural resources. But I always put this example. Argentina is better off in comparison to the United Kingdom in terms of geographical location. In terms of the Falklands, or in relation to the Falklands. The UK will never be able to move the islands to where they are. So in terms of geographical location, because sovereignty is what I tend to say, a multi-level concept. It doesn't only mean natural resources. It doesn't only mean human rights. It means many other things. Yes? That's why we fail to take into account, it's in vogue, and it's been in vogue in the UK to talk about multidisciplinary approach. I don't see it. It's fine on the speech. I don't see it in reality. So what I've been trying to do is to take that kind of multi-level approach. Why? Because all sovereignty conflicts have to do with more than natural resources. All sovereignty conflicts have to do with more than human rights. I'm even including in the cases we have one of the parties with a totalitarian government. I'm even including these kind of cases for this procedure. As long as these parties follow the procedure, they may have a democracy or they may be a totalitarian government. Why? Because I'm interested in these parties to accept the procedure. I'm not discussing their internal ways of behaving or their internal laws or their internal policies. This is a different issue. We are having 3 or 4 or 5 parties deciding on the future of a certain group of people on a different territory, the one we are claiming all sovereignty about. So that's why I talk about limited resources and limited altruism. That's what Rawls says at the society level. I translate this into sovereignty conflict. Limited resources, it's a simple fact. We have 1 Crimea. We have 2 Falkland Islands. We have 1 Gibraltar. They are all discussing about this very limited resource and all that it implies: population, natural resources, law, etc., etc., etc. Limited altruism, I think it's a reality. I think it's mankind. We are not selfish, because I don't want you to die in order to better my situation. However, we tend to be, in all the societies I visit, we tend to be self-centered, which means I'm going to think about me first. In this sense translated, my government, Putin, will think, I dare to say will, not will think about the Russians first. And it's not only Putin. That's why I prefer the Russian style. I tend to be very blunt when I'm talking, very bold. In Britain, I have to be more PC. And this is going to be on the internet, so they're going to watch it anyway. I say this to the British as well. I can talk with real terms here as well. Putin will think about the Russian. Well, he's Russian and he's working for the Russian people. I dare to say it would be a bit naive to think he's going to be thinking about Ukraine or Crimea. He will think about, like, say, Theresa May in the UK will think about the British. She will not say that on the speeches because it's not politically correct, that's cultural. But she will do the same. That has to do with our nature as men and women. We are self-centered. Not selfish, there is a difference. Self-centered. It's not that I want you any bad, however, I'm going to think about myself, and if I'm representing population, I'm going to think first about my population. That's what I assume, that's my assumption. Yes. So if I take all this into account, if I'm having 1 territory populated, Falklands, Gibraltar, Crimea, etc., and I have self-centered populations, I'm going to have conflict, because different populations will argue over the same piece of land. And all that it implies. I'm going to refer to this briefly as a third territory, but I think I'm clear now that it implies everything, sovereignty. Yes? I deal with more detail here, it's just for the presentation. I'm going to spend probably 5 minutes here because this is an incorporation. This is not international public law, and I think we need something like that for sovereignty conflicts. Who may be part of the claiming of sovereignty? Who may have the right to have a voice and to vote in any of these sovereignty conflicts? It is the case that usually any of the parties will say no to any of the others. In the case of Argentina and the United Kingdom, Argentina is not accepting the participation of the Falkland Islanders, simply because they've been implanted. We may disagree, or we may agree that Russia is not accepting Crimea, or they are accepting them to a different extent. The same everywhere. In Kashmir we have the same reality, in Gibraltar, with their differences, but in all these cases we always have one of the parties not accepting or rejecting the participation of any of the other parties. The colorable claim, it's a concept I use from the United States and Scotland, has to do with admissibility, which means the parties will need to show surface legitimacy. They need to have reason strong enough in order for their claim to potentially be accepted as sovereign or as to have sovereignty over that piece of land. The ones I put here are examples of international public law. This is law. Effective occupation, recognition of one of the opponents, other state, or the international community. This is what we have now in international public law. This is one of the grounds. Law, international public law. I address others. I address the historical entitlement. What about people that are living there? What about people that have been removed by force from that piece of land? However, they are still arguing for that sovereignty over the third territory. It's not that they are not there because they don't want to be there. They are not there because they've been removed. And I'm not thinking only about the Falklands here, because you may think, well, he's talking about Argentina. No, I'm thinking about Tibet as well. Tibetans have been removed forcibly, we know that, from their territory. Do they have any claim to sovereignty? They do, according to what I'm trying to show here. Why? Because they have what I call one of the many Colorado claims. We have the historical, the legal, we have the moral standing. Any decision, what I mean by moral standing, and not that I'm thinking about wishful thinking or wishful ideas. Any decision about sovereignty in any of these places, Tibet, Crimea, Kashmir, Gibraltar, Quebec, will have the main effect on the population that is on that piece of land. It may affect indirectly the British, it may affect indirectly the Russians, it may affect indirectly the Spaniards,